The following is a paid program. The content has been provided by Vastola Legal. WFTL, its staff, management, and ownership are not responsible for the content. Some of the opinions and endorsements provided herein were in exchange for compensation from Vastola Legal.
Are you ready for some free legal advice? We can hear the roosters, but it's never too early to know your rights. Feel free to call into the show in the next 25 minutes with questions of your own. Just dial 877-850-8585. Without further ado, here's your host of Know Your Rights, Attorney Jeff Vastola.
Well, good morning, everybody, and thank you so much for tuning in. It is February 10th, 2019, and I am Jeff Vastola, your host for the next 30 minutes of Vastola on the Law. This is 30 minutes of free legal advice. If you have a question of your own and you'd like some free legal advice, just call the number 877-850-8585. I'm here with my trusty board operator, Elliot, who will take your phone call and put you live on the air. So don't hesitate. You can call and ask me anything that you want. I am an attorney with over 22 years of experience. I have offices in Palm Beach Gardens and Stewart, and I practice in the areas of personal injury and wrongful death caused by any kind of an incident. We're going to be talking about automobile accidents today, the do's and don'ts, slip and fall, product liability, medical malpractice, anything like that is what I do. But on Sunday mornings from 6:30 to 7, you can call me about any topic that may be going on in your world, and you'd like to have some free legal advice before venturing out further and perhaps spending money on a lawyer. So before too long, I'm going to get to Dara's call from last week. Dara called in with a question about how to become a Florida resident. So I did some research into that issue, and as always, when you start researching something, it becomes pretty interesting, and I can speak for myself. I always learn something new when I have to research a topic for somebody. So thank you, Dara, for calling last week. I will get to your answer in just a moment. I just want to make sure that people know that they can reach me 24 hours a day, 7 days a week by dialing 833-VASTOLA. That's 833-827-8652. That's a toll-free number. It doesn't matter anymore these days, toll-free or not. But that phone number goes directly to my cell phone, and I will either answer the call, or if you leave me a message, I will return your call promptly. And that makes certain that you have access to me 24/7. That number again is 833-VASTOLA. If you have a case that you might want to discuss with me, feel free to use that number, and I'll be happy to talk to you. No obligation. I always tell people there's no obligation. You don't have to feel as though you're committed to hiring me just because you're dialing the number. You can call me with any question that you have. You can feel me out to make sure that you have a level of comfort with me. And if you decide that you want to use me, well, that's great, and we can go from there. If not, so be it. I wish you the best. Just keep that number handy. The number to reach me anytime, anywhere is 833-VASTOLA. And one of the reasons why I'm emphasizing that number a lot in particular today is because, believe it or not, people do use that number from the scene of an accident just to make sure that they're doing everything that they should be doing, or I think more importantly, when they have questions. I don't make these things up, but I had a person call me from the scene of an accident, and she was very upset because she felt like the officer was ignoring her request for an ambulance because she felt like she was hurt, and the officer apparently didn't think that she could have been hurt given the circumstances of the crash. So just as an example, that's somebody that used the number to call me to say, what should I do? And I encourage anyone to do that. It doesn't even have to be at the scene of a crash. It can be any time. If you have any questions at all, 833-VASTOLA. That's V as in Victor, ASTOLA. As I mentioned before, this is 30 minutes of free legal advice, and I really do want you to call in with any question of your own. The number to call into the radio station in these next 25 minutes or so is 877-850-8585. And Elliot will take your call, then he'll put you on the line with me, and off we go. So before I get caught up in more phone calls and run out of time, let's talk about Dara's call from last week. Dara called and asked, what are the requirements to be a Florida resident? Well, I didn't know, so I did the research, and And what I found, interestingly, are a couple of Florida statutes that deal with this. The first one is that I'm going to talk about is Florida Statute 222.17. It has to do with homestead and exemptions, and it's entitled Manifesting and Evidencing Domicile in Florida. And it says that you can actually go down to the courthouse and file a document, a sworn statement, that says you have the intent of making Florida your main domicile. Now, also, alternatively, for people that have, they call it an abode, for people that have an abode in Florida, but they don't want Florida to be their main domicile, you can evidence an intent for Florida to not be your state of residence by filing the alternative. But if you're deciding that you want Florida to be your main state of domicile, you can go file this sworn statement in the courthouse. But the answer, frankly, to Dara's question about what can I do to become a Florida resident, it's not a black and white, do this and you're done. Filing the sworn statement in the courthouse creates a presumption that Florida is your main residence, but that presumption can be overcome in the event somebody wants to try to prove otherwise. So let's talk about then Florida Statute 196.015. This is entitled Permanent Residency, Factual Determination by Property Appraiser. And so this goes along those same lines, but it says intention to establish a permanent residence in this state is a factual determination to be made in the first instance by the property appraiser. Although any one factor is not conclusive of the establishment or non-establishment of permanent residence, the following are relevant factors that may be considered by the property appraiser, etc., etc. Number one, and this is what I mentioned a moment ago, a formal declaration of domicile by the applicant recorded in the public records of the county in which the exemption is being sought. That's the homestead exemption. Number two, evidence of the location where the applicant's dependent children are registered for school. Number three, the place of employment of the applicant. Number four, the previous permanent residency by the applicant in a state other than Florida or in another country, and the date that that residency was terminated. Number five, proof of voter registration in this state. Number six, a valid Florida driver license. Number seven, issuance of a Florida license tag. Number eight, the address as listed on federal income tax returns. Number nine, the location where the applicant's bank statements and checking accounts are registered. Number 10, proof of payment for utilities at the property for which permanent residency is being claimed. So those are 10 different ways that beyond a shadow of a doubt you could probably prove residency in Florida. But remember, you can always go down to the courthouse and just file your sworn statement. That doesn't conclusively establish anything, but hopefully, Dara, that answers your question as to the things that you can do to establish permanent residency in the state of Florida. So if you have any follow-up to that, feel free to call into the show. If anybody else has follow-up to that, feel free to call into the show. And more importantly, if you have a question of your own that has nothing to do with this, but it's just something going on in your world and you'd like some free legal advice, call 877-850-8585, and we'll be happy to get you on the air and make sure that you get an answer either today or next week. If I cannot answer your question here and now, then I'll do the research I have to do, and I will get back to you the following week, much the same way I did with Dara's question from last week. So let's switch gears again and talk about automobile accidents in Florida. What should you do? So what I'm going to do is I'm going to talk about an accident, a run-of-the-mill accident in Florida, and what you should do from the scene and thereon, okay? Because at the scene, there are certain things that you should do. Number one, be very honest with anybody that talks to you. If you caused the crash, if you're able, get out and ask others if they're okay. Believe it or not, there's a Florida statute that requires you to render assistance if you've caused a crash. So if you've caused a crash and you know it's your fault and you know that you've hurt other people, it's not okay to sit in your car. You're supposed to get out and help if you can. If you didn't cause the crash and somebody wants to come up and start an argument with you, or worse, you know, has caustic behavior, stay in your car and dial 911. and say, keep the windows up and say, I'm not going to have anything to do with this person. I've had plenty of clients that come into my office that say this guy rear-ended me, and he got out of my car and started yelling at me like it was my fault. People do strange things. So if you're in an awkward situation, dial 911. And frankly, if anybody's hurt or if there's any property damage at all, then you're supposed to call 911 anyway, because you are supposed to report your accidents. But at the scene, you may find that although the accident was pretty clear-cut in your mind, the officer will not cite the other driver. That may seem strange to you, but believe it or not, it's becoming more and more common that if the officers themselves do not witness the crash, and believe it or not, that does happen. There are accidents where the officers witness the crash, and then they're able to simply cite the other driver because that officer is a witness to the crash. But in those crashes that are not witnessed by the officer, if there are no independent eyewitnesses, the officers are often reluctant to issue a citation because it's a he said, she said. And there's a presumption of negligence in a rear-end auto accident, for example, that the driver from the rear caused the accident, but that presumption can be overcome in certain instances. And so for those reasons, the officers, I guess, are reluctant to issue a citation. So be careful when you're at the crash, if possible, to document the scene. And that means taking pictures of your vehicle, taking pictures of the other vehicles that are there. You're allowed to do that. If the other driver says you're not allowed to take pictures of my car, you certainly are. And take pictures of the accident scene before the vehicles are moved, if possible. Oftentimes. Great. All right. I'm going to go ahead and take Conrad.
From Delray Beach.
Awesome. Thanks, Elliot. Conrad from Delray Beach. Good morning. How you doing, Conrad?
Good morning. I'm doing fine. I have something here that probably can't do anything about it, but I just wanted to say what happened.
Sure.
I bought a car the last day of November. That would be 2018, like 2-3 months ago, and from a local Dodge dealer. I don't know if you want me to give the name or not.
We don't want the name. Thank you very much.
You don't want the name, okay. I would like to advertise it. But anyhow, I wanted to pay cash, and they told me I would be better off if I made it the total in 3 monthly payments. That it would only cost me like 3 months of interest, which would come to maybe a little over $100. So they talked me into that, and for my first payment, instead of and it's not through that, it would be through like a
finance company,
through a bank.
Yep.
So for the first payment, I wanted to make sure that everything was right. So instead of just sending in the 1/3 of the total, I went to the bank and I talked to the person there, and they said, no, this would be a terrible thing to do. This would cost you an awful lot to prepay that in 3 months, because there'd be all kinds of penalties. They said it would cost you an awful lot of money to make it in 6 payments, and then it would work out okay for you. But this way, I've got to pay. It cost me like almost $200 a month payments for 6 months. So that was a total lie. But I guess there's nothing that I can do about it. It's just I tried calling them on it many times, and they won't even answer my call.
Well, the difficulty with making any kind of a grievance or bringing a case against an automobile dealership, first of all, is the written agreement. The written agreements are lengthy, written on both sides in very small ink, and unfortunately, a lot of times they're enforceable. So there is oftentimes a 3-day right of rescission, but you said you bought this at the end of the end of last year or something like that. So you're well beyond that.
Yeah. About 3 months ago.
And if you are going to bring a claim against a dealership, oftentimes they contain these arbitration provisions in them. So now a claim like this would not be as difficult as what I had alluded to a couple of shows ago, where you're going to be stuck in arbitration for a couple of weeks. But a case like this would go to arbitration for a day. The dealership would likely have to pay the cost of the arbitrator. But if you're really inclined to do something about it, there are lawyers in town that will consider taking your case, and they might even consider taking your case without charging you, because the contracts have a prevailing party attorney's fee in them. But the best advice that I can give you today is to be aware of the prevailing party attorney's fee, because if you take this case because you've decided that it's really important to you as a matter of principle, understand that if you lose, you're going to wind up having to pay the attorney's fees for the car dealership. And as you can imagine, the car dealerships hire very expensive lawyers, and they generate a lot of work. So even though you may be fighting over, at the end of the day, you're talking about maybe a couple $1,000s that you've had to pay extra, the attorney's fee penalty that you'd have to pay if you lost could be tens of thousands of dollars. So, that's the caution I give you.
I know that. I just wondering if there was some, because I have nothing in writing that they told me that. So I don't have a case. They'll say no.
Well,
you didn't.
There's oftentimes ways to use circumstantial evidence, even though it may not be in writing. For example, if somebody was with you during the transaction, and somebody would be able to testify that yes, the general manager, told my husband this, and this. Sometimes, especially in an arbitration setting where the rules of evidence are very much relaxed, you can get in circumstantial evidence to prove otherwise what's stated. So it really is just a matter of a decision for you to decide how important is this, and do you want to try to find an attorney who's willing to take it to be compensated via the attorney's fee provision. What they might require you to do is actually pay them first, and if there is any reimbursement, then you would keep the reimbursement. So you might be, the old saying is, you might be throwing good money after bad.
That's what I think. That's what I think would happen, because I don't have it in writing that he told me 3 months. Because
so he told you 3 months, but it ended up being 6 months. Is that what you're telling me?
Yeah, it was 6 months.
Yeah.
But if
well,
I would
have
just gone ahead and done it in 3 months, it would have cost me a lot of money. So I'm very happy that the first payment to the bank, I went to the bank and talked to the people there. And if I hadn't done that, if I just paid it in, it would have cost me a lot more than it is. Now it's going to cost me like probably $1,000.
Did you have somebody review?
It would cost me a lot more, because
Conrad,
there was no way to do it for the 3 months.
Conrad, did you?
Okay, thank you very much.
Okay, thanks for calling, Conrad. I appreciate it.
Mention the name.
No, let's not do that, please. But thank you for calling in, Conrad.
Many times, and they know they did wrong, and they won't even answer my call.
I understand. I'm sorry you're going through that. All right, thanks. Appreciate that, Elliot. All right, Conrad, thank you for calling in. And one thing I just wanted to mention, I wasn't able to break through because I guess you couldn't hear me, was to make sure you read the contract to confirm that there are prepayment penalties, because a lot of times these contracts will say that there are no prepayment penalties. And so what they did, Conrad, is they probably talked you into some kind of a finance arrangement instead of paying cash, because when these car dealerships use these banks and these finance companies, it's a you scratch my back, I'll scratch yours type of relationship. And somebody that comes in to buy a vehicle with cash, well, they're not using a bank. Obviously the dealership is not able to throw some business towards the bank. And so they talk their customers into a short-term financing arrangement like this. And all of the financing fees are built into that very short-term loan. And because the bank is guaranteed that they're going to get paid those short-term fees, oftentimes the contract will say there's no prepayment penalty. If you want to pay all of this in one payment, go ahead. But what the dealership did is they talked you into spending extra money for finance fees that you didn't have to pay. So as a warning to anybody out there that's going to purchase a vehicle with cash, make sure that you understand that if you agree to finance something, even in the short term, you're likely going to pay for some kind of an interest or a finance fee or administrative fee or whatever they want to call it that you don't ordinarily have to pay for. Now, the dealerships might have something going on. They might have specials going on. They might have rebates going on. For example, there may be rebates with the manufacturers where it's understood that if you want the rebate, you have to finance with the actual car company. So maybe the salesman was looking out for you. We obviously just don't know enough about the transaction to know, and so we appreciate you not giving us the name of the dealership. We don't want any defamation claims coming through. So anyway, I'm told I'm running out of time. Boy, 30 minutes flies pretty quick. So at the scene of a crash, document everything. Talk to the officer. Try to convince the officer to cite the other driver if you can. After the crash, understand that if your vehicle is towed from the crash and taken to a tow yard, you are going to be charged storage fees by day, and they can be as much as $25 to $50 a day for your car to sit in a tow lot. And if there's going to be a dispute between the other driver and you and the insurance companies as to who caused the crash, the insurance companies may not be going over there to get the car. And you may say, well, I'm just going to let the car sit over there. It's their fault. I don't care. Well, you need to care because ultimately the tow yard is going to come after you for the storage fees. And I've seen storage fees accumulate to thousands of dollars because people don't come see me right away. It's a month or two after a crash, and I ask them, well, where's your car? Oh, it's still at the tow yard. I'm like, oh, boy, that's a big red flag for me because I know that tow yard is going to be asking for a lot of money.
What if that car is registered in someone else's name, though?
Well, then whoever owns the vehicle is going to get the bill. So be very careful if the tow yard is registered to somebody else and sits in a tow yard and the owner of the vehicle is not even aware of it. They're going to get a pretty ugly surprise. So be careful with storage. And I'm running out of time, so I want to crank out a couple of other things real quick. If you're injured in the crash, understand that the insurance that you carry on your own policy is geared to make sure that you can get medical treatment. So don't think, oh my gosh, my back really hurts, but I can't afford to go to the emergency room. Don't think like that. Your personal injury protection on your policy, the reason the state of Florida requires that you carry that is so that you or anybody in your vehicle, whether they're related to you or not, or if you hit a pedestrian, even that pedestrian, they're covered for up to $10,000 in medical bills. The way it works is it pays 80% of a reasonable, but it's there. The money is there to make sure that you can get some treatment to make sure that you're going to be okay. So I've had people that come to my office several weeks or even a couple months after a crash, and I say, well, why didn't you go see somebody? And their response is, well, I can't afford an emergency room trip. You know, if I get x-rays and a CAT scan, it's going to be $10,000. And, you know, x-rays are cheap, but they're right. A CAT scan is a very expensive test. But don't think that you can't afford it because the money is there, assuming that you've got coverage on the vehicle. And I guess the last thing I want to mention before I run out of time, because I know Elliot's going to tell me I'm out of time, is that all right. So the Florida law changed several years ago, and I'm assuming it's because of the lobbying efforts of the insurance industry. As a matter of fact, I'm convinced of it. And the law in Florida now says that if you do not get treatment for an emergency medical condition within 14 days, then you can lose your PIP benefits or a substantial portion of them. Now understand that every month or every 6 months, you're paying a premium to your insurance company. You're giving them your money so that you can have coverage on your vehicle. One of those coverages being PIP, personal injury protection, which is that coverage that will pay for your treatment. If you don't go to get treatment within 14 days for an emergency condition, you lose your PIP benefits. And that's money that you've paid for to make sure those benefits are there for you. And the thing is that most people I talk to are not aware of this law. So if you go somewhere 15 days after a crash, be careful because of what I said just a moment ago about, go get treatment, go make sure that you get seen. Well, now your insurance company can say, you waited more than 14 days, so we don't have to pay for that. Now, to me, that's garbage. And I don't know, why the legislature agreed to pass that law, but the automobile insurers are saving millions of dollars every year now because all of a sudden they don't have to pay for treatment. It's not uncommon for people to wait a couple of weeks after an accident to say, wow, you know what, this nagging pain in my shoulder is just not going away. I thought that was from the seatbelt, and I thought that was going to go away. Now come to find out, they've got a shoulder tear or something. It's not uncommon for people to wait more than a couple of weeks to go get treatment, but when they do now, they've lost out on perhaps up to $10,000 of medical care. So, hopefully you've got the health insurance, or if you don't, then you can speak with an attorney that handles automobile accidents, and we'll give you the rundown on what are called letters of protection so that you can be seen and not have to pay while you go if you can't afford it. But if you have any questions at all about an automobile accident and what you should do either at the scene or afterwards, please call me. If you have an attorney, speak with your lawyer first. I'm not here to Monday morning quarterback other lawyers, but if you have a question, use the number 833 Vastola. That's V as in Victor, ASTOLA, 833-827-8652. You can use that number anytime, even from the scene of a crash, because believe it or not, people do it. There are those that thumb their nose at that and say, oh my gosh, the first phone call you made was to a lawyer. Well, the first phone call that you make, should be to a loved one to say, hey, I was in a car accident, and hopefully you're not injured. Your first phone call perhaps should be 911 if it's a serious crash or if you're hurt. But make that phone call from the scene if you don't know what to do. Because preserving evidence at the scene of a car crash is really important if you're going to be pursuing a claim, because the marks on the road left from tires will disappear. The damage to the other vehicle may not be easily accessible to you, at least in the claim stage of things. So if you need me, I'm here 24/7. 833-VASTOLA is the number to use. Thank you so much for tuning in to Vastola on the Law. We're here every Sunday morning from 6:30 to 7 to give you free legal advice. We thank you for tuning in. And remember, do the right thing. Thanks, Elliot. Take care.
You've been listening to Know Your Rights with attorney Jeff Vastola. Tune in next week for more free legal advice and answers to your specific questions. You can call Jeff on his cell phone after the show by dialing 833-VASTOLA. That's 833-827-8652.